Good morning, Deputy.
Good morning, Judge.
Who do
I
you
wanted,
have for me? I'm good.
I
How are
wanted,
you?
I'm well. I wanted to just log in and let you know, I know the court called and said they were ready on Corey Jenkins. My partner went to go pick up Mr. Jenkins and he is not available. He's out to medical right now. He's not on his floor.
Oh, okay. Well, then hold on. Let me bring in this lawyer.
Okay.
So what does that mean? Like how he's gonna, you don't know how long he'll be?
I don't. He
Okay.
could take an hour or it could take, until 4 p.m. I'm not sure, unfortunately.
Okay. Let me change the settings. Miss Robinson, can you come on video, please? Miss Robinson?
Yes, Judge Bryant, here I am.
Okay. Miss Robinson, the jail has logged in. However, they've informed the court that your client is not available. He's in medical and they don't know how long he'll be. So I will adjourn your case.
Yes, Judge.
It's going to be rough. Let me see. What was he? He was, it's a final pretrial. Can you come back tomorrow, Miss Robinson?
Um, it'll be, I can make it happen, Judge. It'll be a little tricky, but I'll make it happen if the court's
You-
patient with me.
Okay. What about Wednesday? Is that
Wednesday
better?
is equal, it's
Oh,
equally tricky. But
okay. Well, I would prefer to do tomorrow because Wednesday and Thursday I'm also covering exams. So I would prefer to do tomorrow. So I'll be patient with you tomorrow. Okay, so Deputy, if
Your
you all can just,
Your
I'll
Honor,
adjourn,
I,
I'll adjourn to
I,
tomorrow. Yeah.
Your Honor, would the court mind adjourning till January? My client is in custody on another matter. His trial's in June on a capital
Oh,
offense.
okay. I don't mind. That works. That works for me. That works for me. So let's adjourn it then till January the uh let's see. Mr. Flanagan, how many do I have? January this no, I know I'm trying to do something that day. January the 9th, how many do I have?
$20.
And does that include some 8:30s from the magistrates?
Oh, I'm sorry. Yes, Your Honor. 5 are on there for arraignment on the bench warrant.
Oh, but no pre-trials?
Just one pretrial at 8:30, and there's pretrials at 8:35.
Hmm. I don't know. Okay, let's go to no, let's go to the following week. Let's go to January 17th. How many do I have?
20 with 4 pretrials at 8:30.
Okay, let's just do January 17th. I'll adjourn to January 17th, and Deputy, I'll send over the paperwork to the jail.
Thank you, Judge.
Thank you. Thank you, ma'am.
All right. You're welcome. Thank you. Have a great day. Stay safe.
Yes, ma'am.
All right. Thank you. Okay. Good morning, Mr.
Judge. How are you?
Nasser.
Good morning, Judge. How are you?
I'm wonderful. Thank you. How are you?
Oh, always good to see you, Judge. Always good to see you. Thank you.
You are here for which case?
Horatio Jones, Judge.
Oh, okay. All right. Mr. Jones is in the waiting room now.
Great.
Um, Let me. Mr. Murad, go ahead and tell Miss, can you let Miss Stevenson know that I'm gonna be ready on Henry? I don't want to keep.
Well,
Oh,
she's here.
there's Miss Stevenson. I didn't even see your square. Okay. All right. So I'm gonna actually do Jones. I'll get Mr. Nasser on his way, and then I'll be ready on Henry.
Okie dokie.
But I'm just gonna confirm a couple of things first. Good morning, Mr. Hayes. Can you unmute for me?
Morning, Your Honor.
All right. Thank you, Mr. Hayes. Good morning, Mr. Jones. Can you unmute for me and tell the court your name?
Horatio Jones.
All right, thank you. I am going to enable the video. Mr. Hayes, which case are you here for?
Your Honor, I'm here on Mr. Jenkins.
Mr. Jenkins. Oh, Corey Jenkins?
Yes.
Really?
Yeah. Really?
That's an assault and battery.
It is. It happened at the casino, though. Co-defendant already pled. We've gotten discovery to defense, but I know at least he was incarcerated, so I'm not sure what the story is currently.
Okay, yes, he's still incarcerated, and I didn't know you were on the case, but the jail came on to advise us that Mr. Jenkins was actually in medical and could not come to court today, so I adjourned him to January what did I adjourn him to? January 17th, I believe.
Yes.
Okay, perfect.
Okay, so yeah, January 17th.
All right, thank you, Your Honor.
All right, you're welcome. Have a great
Have a
day.
great day.
Stay safe. All right, you too. Okay, looks like I'm ready on Jones. This is case number 204452101, the People versus Horatio Capone Jones. Defendant is charged with 1 count of driving while license suspended, revoked, denied, 1 count of reckless driving. And today is the date set for a final pretrial conference. Mr. Jones, can you back away from your camera a little bit? Thank you so much. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505. And judges should be driving while license suspended, revoked, or denied second or subsequent offense notice.
Okay, thank you.
You're welcome.
And good morning, Your Honor, and to your staff. May it please this most honorable court, Mohammed Nasser, P74485, appearing on behalf of Horatio Jones, who appears via Zoom, consents to the hearing over Zoom. Mr. Jones, please state your name once again for the record.
Horatio Jones.
What's your middle name, Mr. Jones?
Capone.
Thank you so much. Today is the day set for final pretrial conference. Mr. Nasser, how are we proceeding?
Judge, and I apologize. I'm standing in for Attorney of Record Edward Martell with Mr. Jones's permission, correct?
Yes.
I believe that Mr. Martell has spoken to the fine prosecutor, and there's an offer in which the original counts would be dismissed, and he would plead to the amended count of careless driving, which is a civil infraction, if that is correct, Ms. Ritter.
So, Judge, the correction is that the people agreed to amend count 1 reckless driving to careless driving and amend driving while license suspended, revoked, or denied second offense notice to first offense.
Okay, but so, okay. So, Mr. Nasser, with that correction, number 1, does your client still want to accept the offer? He would be still pleading to driving while license suspended, first offense notice.
He would, and that would suspend his license once again. Mr. Jones, you do have a license, correct?
My license been suspended since I missed that court date a few whiles back when I last seen you guys.
Right.
Okay. And then, but Ms. Ritter, with respect to the people's offer, has the ticket already been rewritten?
It has, and I submitted it to the court not too long ago.
Okay, great. Okay. Okay, so then, Mr. Jones, you would like to accept the people's offer?
Yes. Will I get my license back today?
No.
No, he won't, Judge. You know, Judge, I apologize. Like I said, I should have spoken more thoroughly to Mr. Jones and talked to Mr. Martell. This offer will suspend his license because it's a driving while license suspended first, which will suspend his license automatically. So in light of same, may I set this for one more pretrial? I'll take over the case and talk to Ms. Ritter. That Mr. Jones did have a license, but got suspended based upon a mislapse related to our change of firms and the like. It was originally PLG and it's no longer.
Right.
However, I don't want this young man to have his license suspended once again. So I'd ask for one more pretrial if possible.
Okay, yes, we could do that. What about that January 17th date? Are you available that day?
I am, Judge.
Okay, so then I will continue a not guilty plea on behalf of Mr. Jones, and I will adjourn the final pretrial conference to January 17th. I'll leave it at 9:14. That meant it was on the jury trial track, so I'll leave it at 9:14, and then we'll see where we are in January.
So what about my license now?
I want you to stop asking me about your license, and you can talk to Mr. Nasser about your license. Your suspended license has absolutely nothing to do with me. Has nothing to do with me. That's why Mr. Nasser said he was going to talk to you more thoroughly with respect to the license issue. It has nothing to do with me. So we're going to adjourn to January 17th at 9:14, and Mr. Nasser is going to talk to Mr. Jones about his license.
Correct, Judge. Thank you so much.
You're welcome. Everyone have a great day. Stay safe. Happy holidays to you.
Happy holidays, Judge. If I don't see you and your staff and Ms. Ritter, I'll give you a call. Thank you so much.
Okay, you're welcome. All right, I'm ready on Henry. Oh, and then one moment. I needed to bring him. Well, why would, okay. Ms. Rahal, I believe that's who it is. Please unmute and state your name for me.
I'm Miss Randall.
Oh, okay. Miss Randall. Miss Randall, oh yes, I do. Okay. We're gonna send Miss Randall to, please accept to join the breakout room, ma'am.
Okay.
All right. Okay. I have now engaged the video. Everyone, please start your video. Okay. Oh, I see what you meant, Ms. Ritter, with respect to, okay. Ms. Henry, I need you to start your video. Okay. All right. And then if you're a family and you are not speaking, as I believe you said Mr. Lee was not, you don't have to be in camera if you're not speaking, Mr. Lee. I mean, you don't have to have your camera on if you're not going to speak, Mr. Lee. Okay. All right. This is case number 234467001, the people of the state of Michigan versus Cecilia Henry. The defendant is charged with one count of moving violation causing death, and today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I also have family members on behalf of Mr. Eldridge's, the deceased complainant witness in this matter. Your Honor, I will start with Miss Tiffany Eldridge, if she can unmute.
Well,
And
let me interrupt you, Ms. Ritter. With respect to the family members, only if they're going to speak do I need their names for the record. Okay.
Understood. Okay, so Miss Eldridge, can you unmute and state your name, please?
Tiffany Eldridge.
And I do see two other individuals standing in the back. Will they be making a victim impact statement as well, Miss Eldridge?
Yes.
Okay, can I have their names for the record?
Kelvin Eldridge.
Kelvin Eldridge.
I didn't hear the female's first name. I'm sorry.
How is she? I'm Tiffany.
No, the other female.
Larica Eldridge. Larica Eldridge.
Okay, thank you.
And then Ms. Payne, can you unmute yourself and state your name for the court?
Yes, Tyra Payne.
And Judge, Ms. Payne does have on here where that is for religious purposes.
Yeah, it looked appropriate.
Thank you. And the young man that's in your background, Ms. Payne, will he be making a victim impact statement today?
Jonell Eldridge.
Thank you.
Okay, today is the date set for sentencing. I do apologize. I'm going to interrupt this case just briefly. For Mr. Pearlman. Just give me one moment. Ms. Stevenson, go ahead and put your appearance on the record and your client.
Thank you, Your Honor. For the record, Janice Stevenson appearing on behalf of Miss Cecilia Henry. Ms. Henry, ma'am, please unmute and say your full name.
Unmute, Ms. Henry, please. Unmute.
Cecilia Henry.
All right, thank you. Okay, give me one moment. Mr. Pearlman? Mr. Pearlman, are you present? Unmute for me, Mr. Pearlman. Oh, I changed it. I'm sorry, you couldn't unmute.
Okay, now, yeah, I wasn't able to unmute.
Okay, Mr. Pearlman, good morning. If you're ready, I'll take your case now, but because I'm getting ready to start a sentencing with several victim impact statements. So are you ready to proceed?
We are ready to proceed, Judge. We are ready to proceed on Donta Hall.
Right. Okay. So I'm gonna. Well, let me ask you this: what are you just getting a date, or is this a plea?
We're gonna schedule it for a bench trial.
Okay. All right. So the parties on the Henry case, please, just give me one moment. Okay. I should have brought Mr. Hall in earlier. He's not connected. Let me see if he can connect. Otherwise, you're gonna have to wait until after the sentencing, Mr. Pearlman.
Well, if I could wait.
Say that again, Mr. Pearlman.
If he's unable to connect, I would request to waive his appearance, perhaps, if the court would allow.
Okay, let's see. Nope, there he is. And let's see if he's going to connect. There he is. Okay. Then I'm ready on Hall. This is case number 224531201. The people of the state of Michigan versus Donta Jamar Hall. Defendant is charged with 1 count of gun reckless use. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Judge. Jeff Pearlman on behalf of Donta Hall, P80517.
Mr. Hall, please unmute and state your full name for the court.
Don Jamar Hall.
Thank you. Today is the day set for a pretrial conference. Mr. Pearlman, how are we proceeding?
Judge, at this time, we'd like to request a bench trial date.
Mr. Hall, by your lawyer's words, he indicates that you want to waive your right to a jury and have the matter heard by the bench. Is that what you want to do?
Yes, Your Honor.
The court is going to continue a not guilty plea on behalf of Mr. Hall. And then with respect to the trial, Mr. Hall, do you understand that if I accept a waiver from you today, that you will not have a jury to hear your case? Do you understand?
Yes, Your Honor.
Sir, has anyone threatened you in any way or promised you anything that was not placed on the record to get you to waive your right to a jury and have the court hear the matter?
No, Your Honor.
With respect to the waiver, is there any objection from the people?
No objection, Judge.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. And then I will set the matter for a waiver trial. My next available waiver trial is Thursday, February the 1st. Mr. Perlman, is that a good day?
Let me just check quickly. Yes, that'll work, Judge.
All right, the court sets the matter for a waiver trial Thursday, February 1st with a 12 noon check-in. Mr. Perlman, do you already have discovery?
I don't know that I have all the discovery. I would just ask I'd ask the prosecutor to please send it again, just to verify that I have everything.
And is there an offer? Was any offer extended from the people?
Judge, the people haven't sent over discovery, so offer has not been extended yet.
All right, I'm going to set a final pretrial conference for Thursday, January 25th, in case there's an offer that wants to be accepted.
Judge, during that time, can you please request a subpoena for the complainant?
The complaining witness should appear at the final pretrial conference.
Thank you.
Court is going to set the final pretrial conference for January 25th at 9:10. Anything further?
Nothing for defense. Thank you.
All right, then we're all set. Have a great day. Stay safe. Happy holidays to you.
You as well. Thank you.
All right. Okay, thank you all for your patience. So now I'm back on the record with Miss Cecilia Henry. With respect to Miss Henry's.
Yes.
Okay, I'm gonna let the jail in, but I thought that was on my docket from before. The court has had an opportunity to review the pre-sentence report. With respect to the pre-sentence report itself, are there any additions, deletions, or corrections on behalf of the people?
Judge, the people had an opportunity to review the pre-sentence report. I don't see any additions, deletions, or corrections on our end.
With respect to the pre-sentence report, are there any additions, deletions, or corrections on behalf of the defense?
Thank you, Your Honor. I did have the opportunity to review the pre-sentence investigation report with Ms. Henry. We do find it to be factually correct, Your Honor. We have no additions or deletions at this time.
Okay, so hearing no additions, deletions, or corrections, then does that mean with respect to plea agreement that there was none?
That is correct, Judge.
Yes,
Okay.
Your Honor.
Okay, all right. Then with respect to sentencing, on behalf of the people.
Judge, on behalf of the people, just going to page 4, under victim impact statement, the probation did indicate that they spoke with family members regarding any funeral expenses, and there is a total. I just spoke with Ms. Tiffany Eldridge, and I did get a copy of the receipts that were sent to probation from Ms. Eldridge. The people are asking the court to set the first review as a restitution hearing as well, so the people have an opportunity to review those receipts and see what would be appropriate for restitution in this case, Your Honor.
Okay,
And Judge, again, the family members are here today via Zoom. And Ms. Eldridge did indicate that there were family members who did want to give a victim impact statement on behalf of the family members of Mr. Rosella Eldridge, Judge. So I'll start with Ms. Tiffany Eldridge, if she would like to give her victim impact statement first.
all right, Ms. Eldridge.
Good morning. Thank you, Your Honor. I think I'm going to just decline. It's so hurtful. And it's just unbelievable that this lady has done this and is receiving potentially this type of, probation has taken a life. I mean, it is just beyond me. As a citizen, as a motorist, as a professional, as a family member. And I just don't know what to say, because nothing I can say will bring him back. I'm just outdone as an investigator myself. I am just really outdone about this situation.
Okay, thank you, ma'am.
I have about the same feelings.
Okay.
Okay, well, hold on. It sounds like there's someone speaking off camera.
This is Larika Eldridge. I was telling my daughter I have this same feelings. I submitted a impact statement to you back in I believe it was October. And I
okay, so pause right there. Pause right there. Ms. Ritter, she says she's saying she submitted a victim impact statement to me. I don't know what she means by that.
So Judge, there were some victim impact statements that were submitted to the prosecutor's office and to the court regarding the Eldridge family. Now, I don't know, I can't speak on the ones that were submitted to the court, but the ones that were submitted to the prosecutor's office, they were scanned in, but I didn't see them as part of this case. So that's why I offered the family an opportunity to speak, because I didn't see them scanned in to share on behalf of the Eldridge family for today's sentencing purposes.
Mr. Flanagan, did you receive any victim impact statements? Are there any victim impact statements in the file?
No, Your Honor.
Okay, so Ms. Eldridge, the Ms. Eldridge that was speaking to me just now about the victim, when you say you submitted it to the court, I'm going to spotlight it again so I can see you. When you say you submitted the victim impact statement to the court, where did you submit that?
I sent it with your name and to 36th District Court.
Okay. Ms. Projetsky, the mail that was received, have we received any victim impact statements from?
No, and I just recently checked it at the end of last week, Thursday or Friday.
Okay. So let me apologize on behalf of the court. Mr. Flanagan, can you call the mail room and find out? She says she sent me some mail in October with my name on it, addressed to 36th District Court. So can you just call and see if they have any? I don't know what that would be. Okay, so again, I apologize that I have not received your victim impact statement, your written victim impact statement, nor is it in the pre-sentence report, which I will say normally, if the probation department received a victim impact statement, they would usually also attach it to their report. So again, I apologize. So ma'am, would you like to make any further statement, or is that?
No, not at this time.
Okay. All right, thank you. Miss Ritter.
Thank you, Judge. And the young man that's in camera, would you like to make a victim impact statement at this time?
Yes. My name is Kelvin Eldridge. I'm the youngest brother of Rosella Eldridge. First of all, I'd like to say to Miss Henry that the impact of the loss of my brother affects me every day, especially since I'm a bike rider myself. And I'm extra cautious when I'm riding, but just the thought of someone running me over all the time is always in the back of my head. Me losing my brother means I won't have my brother with me. Annually, my family goes camping every year. This is the time when we reflect on things we've been through. So I won't have my brother there. I didn't have him here last summer when we went camping. I want to say to you, first of all, that I forgive you. I hope I don't want you to have to carry a burden of condemnation with you all the time. But I hope that by the court showing this leniency in your case, that you take full advantage of it, because my brother was living his life well. And whatever happened with you that day that caused you to act out in a reckless manner, I don't know. But I hope that you take this opportunity and correct that behavior, because maybe this situation happened before you did more damage to someone else. And I want you to think about that. I'm not here to, I don't even have energy to, I'm not here to try to make you feel bad about this, because I understand, I know universal law. You took a life, so you have to deal with that yourself. But I just want you to slow down, because there could have been more lives that you could have taken. Luckily, I'm grateful that my brother was living his life correctly, and I'm confident that from a spiritual perspective that his life was a testament to doing good. So just take this opportunity and just slow down, correct some things in your life, and be grateful for this court showing leniency to you on this. The holiday season coming, you're going to be with your family. I don't have my elder brother here with me. So you took that from us. And I just want you to understand that, but I don't want you to go out and let this burden of life overwhelm you to the point where you do something else reckless. Just take this opportunity and turn some things around in your life. That's all I got to say. Yes.
Ms. Ritter.
Thank you, Judge. Ms. Tyra Payne, if you would like to give a victim impact statement, I'll allow you to do so now.
Okay, can you hear me?
Yes.
Oh, okay. Well, good morning to everyone, Judge and everyone. I would just like to say that to Miss Henry, I forgive you because I want to be forgiven. From my understanding, there were a lot of distractions. I viewed the video and I saw all the other cars braking because they seen him. When you went around the other cars and they were braking, it was just devastating. And because of my line of work, I'm a driver and I'm always paying attention to the roads. Anybody knows me, I'm slow down, keep your eyes open, be aware of your surroundings. And so I was at work driving when I got the call. I didn't answer my phone because when I'm driving, I don't answer my phone. I feel like that's what I have voicemail for. When I get to a safe place, then I will respond. So when I got to a safe place, for some reason that day, I asked my daughter if she could come and drive me somewhere. So when she got there, I answered the phone, answered the call, and this is what I heard. So once again, I would like to say I forgive you. From a spiritual point, I don't know how spiritual you are or if you're a believer. I must forgive you because that's what the Lord wants us to do. But as far as being distracted, a distracted driver, these are the results of being distracted. You don't have to text. You don't have to answer the phone. Our jobs is to pay attention to the road while we're on the road. I'm not sure if you had a family emergency that morning, getting to where you needed to go to, or something happened in your life. But this is a leniency, like my brother said, that they're giving you. You get a chance to enjoy your family. And I'm pretty sure for the holidays, I don't know if people drink and smoke and party like they do. But there's other people's lives out there. And you're going to spend time with your family. And your family's going to be, oh, you won this case. You know, they're going to hug you and things like that. While we won't be able to hug our brother anymore. Every time I'm in a vehicle, I have anxiety. I take medication for that now. Because my life has changed because of a distracted driver. We just lost my brother, buried my brother, and someone hit me being distracted and almost took my life. And now I have difficulties being in a vehicle to drive. So as you sit with your family without any jail time, I don't know. I don't want to take up too much time, but your mind is going to be racing. All I could just say is God forgive you. And as you accept this time, I hope that you will get your life together. Because if you feel like you got away with something, a bigger tragedy will come if you continue to be negligent. So I'm praying for my family, that my family will continue to have forgiveness in their heart, because that's how we were raised, to forgive. And this is our ultimate forgiveness that you will receive. And so thank you, court, for allowing us to be able to express our feelings. This is a very difficult one. Like I said, my life has been changed. Not only was my brother life taken because of a distracted driver, my life was almost taken from a distracted driver. What, a month from him? And it was terrible. So I'm gonna let that be. So as you sit in your quiet moments, those very quiet moments, I want you to be like me and my family. Continue to always think about my brother, Rosella Eldridge. And that's going to be it for me. And then my other brother wants to say something. I guess they'll let him know when. Thank you for that time.
Okay. Miss Ritter?
Thank you. Mr. Eldridge?
Good morning.
Good morning.
Good morning, Your Honor. I'm kind of speechless, and I was thinking back to when we had wrote our impact statements, and the closer we got to this day, I didn't know how I was going to do, how I was going to feel about what I had said on this, or on my victim impact statement. But I thank the court for this opportunity. I wanted to see the face of the person that took my brother's life. Of course, I had a lot of anger. I have a lot of misunderstanding about how things work. Myself has been involved in the system, and I have kind of seen how things work, and I'm not in total agreement with how things are going. But at the same time, I can remember back when I asked for mercy and it was given. And now listening to like my brothers and sisters, and I know how we all feel. We wake up every day with a loss. We have minors in the family, and every day we're still explaining how Uncle Andre is not coming back. We're still explaining that. And it's really weird because we still find people still on the street every now and then and say, well, how's your brother? And I have to tell them I don't know. But anyway, myself being a spiritual person, I do say that I forgive you. I'm not in total agreement with how things are going. I do believe in the system. I do believe that some things are just, you don't get a tap on the hand for. And like my brother also said, I hope that you take this opportunity to reflect on how things could have been different and how things like something like this shouldn't happen again. I wanted to mention just prior to this happening, we had kept some things from kept some things from each other. But like my baby sister said, that after my brother's death, less than 2 weeks after my brother's death, and we was doing the funeral, my only child was hit from behind and almost killed because someone wasn't paying attention. My only child, right after my brother, and we kept it from some of the other family members because we didn't want them to be all because of what had just happened and everything. I will, when it comes to motor vehicles and traffic laws and different things like that, I believe that they should be enforced to the utmost. To the utmost. I don't want to take up a lot of time. Again, I do forgive you, because without forgiving you, I cannot be forgiven. I cannot say that I love Christ without forgiving you. Just hope that throughout your years that you would not forget about our brother, because we won't. And because of what happened, you yourself will always be a part of our life. You will always be a part of our life. And when I go to my prayer closet, I won't forget your name either. And I will always hope that you would be a better person in life. Thank you. Thank you. I'm done.
Okay. Ms. Ritter, anything further from the people?
Judge, I believe that's everyone who wanted to give a victim impact statement on behalf of the family for Mr. Rosella Eldridge. And with that being said, Judge, I believe that's it on behalf of the people.
Okay. Ms. Stevenson, anything on behalf of Ms. Henry?
Thank you, Your Honor. First, personally, as well as on behalf of Ms. Henry, personally, I would extend my condolences to the family. This is a hard hard place that I'm familiar with. And I extend my condolences to the family. I would just take exception to I'm not sure who said it, but one of the family members said that, you know, they are required to forgive and they have to forgive. Well, you know, I believe that forgiveness is a requirement, but I believe we have a choice to forgive. And I commend you for making that choice to forgive, because even though it's required, you don't have to do it. So you are to be commended for choosing to forgive. And I believe with everything in me that Ms. Henry agrees with that. Having had the opportunity to interact with Ms. Henry, I, as a member of the legal community, do not want you left with the impression that this has not been, not to the same extent that you have experienced devastation, but this has been a devastating, horrifying experience for Ms. Henry. She is very sorry. And I'm not sure that she knows even yet what to do about that. And it is a burden. I want you to feel confident that it's a burden, not that you want her to feel burdened, but I want you to know that she feels burdened. She expressed to me that she does not sleep. She will not be driving. So you can be confident that the law is doing something to protect you and something to give you some kind of help in this situation. She has to turn her car in today because her license has been suspended and she can't insure it, so she won't have a car and she won't be driving. That is an act of responsibility on her part, because I know that we all know too well that there are people who would drive anyway. But I want you to know that Cecilia Henry will not be one of those people. Ms. Henry has made just, you know, a horrible mistake. She is not a bad person. She's not. I don't know if she had any kind of traffic problems before. I think if this is the first ticket that she got, it was, you know, I think maybe the second, according to the investigation. It was done by the 36th District Court Probation Department. But she won't be driving. And she won't be forgetting about your family. And she won't be forgetting about Andre. This is tragic all around, and I want you to feel confident of that. Ms. Henry, I believe, has something to say to you.
Ms. Henry, unmute yourself if you want to speak, ma'am.
Yes, Your Honor, I'm so scared and so sorry. I don't know what to say other than, I'm sorry.
Okay, does that conclude your statement, Ms. Henry?
Ma'am, I can't think of anything right now, but I'm sorry. I'm hurting. I'm sorry.
All right.
It happened.
Okay, the court is ready to impose a sentence. I'm going to, of course, make a few statements and observations. So, having heard, first, I want to again apologize to the Eldridge family. I have no idea what happened to your victim impact statements, and I apologize. We're going to try to track them down. Of course, it'll be post-sentencing, but I do believe that they deserve to be a part of the record that you submitted. So I apologize for that. I also want to apologize for not. Okay, I want to acknowledge that's what I want to do. I want to acknowledge. And I was debating if I was going to say anything with respect to this, but I do want to acknowledge a complaint that was received from your family about something I said at the last court hearing. And I don't know if you all were in the courtroom or present, I think I had already sent you to the breakout room when an individual came and I was trying to identify them, and the individual said that he was here on a traffic matter. And then my immediate response to him was, well, I don't do traffic tickets, so let me give you the phone number. So the last time you all were here, one of your family members, I believe, came in and she said she was here for a murder case. And I said, I don't do murder cases. And I understand from the chief's office that she took offense to that. So I want to acknowledge that complaint. I want to say that, of course, I didn't mean any ill intention towards the person, and I don't know if they're present today, but it's my automatic thing that I say. If a person comes on and they have a case that I don't handle, that is just like the automatic thing that I say. And so, perhaps I'll have to look at that in the future. But additionally, I see from your impact statements, and I think it was, I apologize also, I'm not going to be able to remember everyone's name. I usually rely on the name that's, on the screen, but the gentleman that's sitting with the young lady, the brother, he was the last one to speak. And you indicated that you don't agree with how it's being handled. I also think Ms. Tiffany Eldridge said, that she couldn't believe, basically that Miss Henry is going to just get, sort of like what we would call in this process a slap on the wrist. And I want to say and also acknowledge that, there probably may be, depending on what perspective you look at it from, a flaw in the system. A lot of times people misunderstand a judge's authority with respect to cases. I often try to explain to people that I'm not the legislature and I'm also not the prosecutor. So it starts with the legislature who decides that there are situations that for some reason in their opinion, even if it causes death, that it does not rise to the level of a felony. That's a legislative decision. And sometimes when people suffer loss, they become advocates for changes of law, right? I can't tell your family what to do in that regard, but sometimes people become advocates for changes of law when they themselves suffer a situation that they think is unfair, and sometimes it results in a change of law, right? And then the other piece is then the prosecutor's office. So once the prosecutor's office has options, then they decide how they're going to charge the case. And so when they charge these particular cases and then they show up on my docket, I'm already prepared that the family members may be angry about the fact that they've lost a loved one, that their loved one is no longer alive, yet the person is sitting in my courtroom, which is the misdemeanor courtroom. And unfortunately, there's nothing that I can do to make this a felony. And so here we are. Here we sit in the misdemeanor courtroom. I'm also of the opinion that when people show up in the misdemeanor courtroom, it is an opportunity for the misdemeanor court, because in general, we're only going to have a person in front of us for maximum. We could potentially have a person for 5 years, on probation, like the case could potentially be a 5-year probationary case. In general, we have people for 93 days, which means we could potentially have them for 2 years. And then this particular misdemeanor is the highest level for the type of misdemeanors that we handle, which is a 1-year misdemeanor. I believe that when a person shows up in the misdemeanor courtroom, it is an opportunity for us to try to change their thinking, for us to try to change their behavior. While prison is supposed to be a place where we look for people to be rehabilitated, it is not. It is not, in most cases, a place of rehabilitation. And so when the people do show up here in the misdemeanor courtroom, I attempt, sometimes it's not always successful, but I attempt to make a change in their lives, in their behavior, in their thoughts, and all of that. Ms. Henry, I have only read the report. I have not seen the video. The prosecutors, after reviewing the video, decided to give you this opportunity here and charge you with the misdemeanor. Ms. Henry, what I'm going to say is I don't know what I would do or think or feel if my loved one died and the person who was responsible for that death was charged with a misdemeanor. I don't know how I would feel. I don't know what I would say. I don't know how I would think. Even being a judge and knowing that there is such a thing, I don't know where that would take me emotionally, right? I believe that you are remorseful. However, I hope that these type of cases will show people to drive responsibly, right? To drive responsibly. I don't know if you were distracted or if you were just impatient, Ms. Henry. People, for those who know me, my friends and family, they know that if somebody rides real close to me on the street, I'm going to slow down, right? If somebody comes up to me and they riding on me, I'm going to slow down because I want to make them slow down. Now, sometimes it doesn't work and they'll speed around me trying to get where they're going. Well, this is what I have to say about that. I don't know where you were going that day, Miss Henry. I don't know what you were doing and I don't know what you were thinking. Now, the report says that you went around to try to avoid hitting the cars in front of you. But let me tell you what that says, Miss Henry. That says you were going too fast and you weren't paying attention. Because if you were, and you may have been riding too close, you might have been one of those people riding too close to the car in front of you where you're supposed to have a car length between you. The reason for the law about the car length between you is that if the car in front of you suddenly stops, you have enough space to also stop because you're supposed to be paying attention to what's going on in front of you. Whatever happened, you didn't do that day, Ms. Henry, and it caused a loss that these individuals will never be able to feel with. They can't bring their loved one back, right? I'm a biker too. Somebody said they were a biker. I'm a biker too, and then it bothers me when people park in the bike lane, right? It bothers me when you don't, kind of look out for the bikers and whatnot. And so we have to just be more responsible in our driving. I am ready to impose sentence, but I do see the hand up of Miss Eldridge's device. Did you need to say something else to me?
I just want to say thank you for acknowledging, as you did, that that form that was filled out. And thank you also for acknowledging, legislation, et cetera, because I am the Equal Employment Opportunity Officer for the Michigan Department of Transportation. And so it's very interesting that this happened a month after I took my tenure. And so, that's as we look at how we do mobility in Michigan and throughout the country and bike lanes and things like that, this has been brought to the forefront of a lot of the top officials, right? Because hey, it's something that happened to their colleague, and it's just really unfortunate. But I'm glad that you addressed that. The process is the process, and we have to follow the process if we, as the people, do not like, what has been set forth because we are changing, right? Things are
Right.
evolving, and how we do mobility because everyone doesn't
Yes.
do the motorized vehicles. But that's all I want to say. But thank you.
Okay. You're welcome. So, Miss Henry, I am ready to impose sentence, and I'm going to do so as follows. Now, Miss Henry, let me tell you something about me. Miss Henry, I'm straight no chaser, and it kind of gets me in trouble sometimes. I was watching this one judge on court TV doing this trial, and she was just so like, I don't know, her personality was just so whatever. The lawyers were like disrespecting her and stuff, and she just wouldn't. I almost didn't even acknowledge their disrespect, and then she would just repeat like, "Well, I've already ruled" or whatever. And I said to one of my friends, I said, I watched her, and that's not me, and I don't want it to be me. Now, sometimes my passion for justice may not go over the way I guess they wanted to in terms of judges, but I'm going to tell you something about me, Miss Henry. Before a person is convicted, meaning before a person pleads guilty or is found guilty, I believe wholeheartedly in that person's constitutional rights, that they are innocent until proven guilty. I don't care what the video shows. I don't care what the, report shows. I am wholeheartedly a person who believes that an individual accused of a crime is completely innocent until proven guilty. And a lot of times, Miss Henry, when I'm in the pre-conviction mode, dealing with the person, I'm accused of being pro-defense. I'm accused. I've never been a defense attorney in my life, I've never been a criminal defense attorney in my life. Well, I'm not being honest. A small part of my practice at one point was criminal defense. And then people accuse me of being pro-defense. But Miss Henry, at the point of conviction, which means you plead guilty or you're found guilty, now I'm completely from the perspective of it is time for you to pay for the crime that you have been convicted of within the limits provided by law. And then sometimes when I'm in that mode, people accuse me of being pro-prosecution. Well, let me tell you, I'm pro-justice. I'm right in the middle where I'm supposed to be. Before you're convicted, your rights are protected. Once you are convicted, you are convicted. Miss Henry, I believe that you are remorseful. I accept that you feel bad about what happened. And now I'm interested in you changing your behavior, your thoughts, your everything else about you. I'm also going to tell you, Miss Henry, that for these type of cases, this is how I feel. Even though it's a misdemeanor, we're never going to act as if nobody died. So even though it's a misdemeanor, and all I have are the tools within the misdemeanor sentencing, we're never going to act like somebody didn't die. So when you approach this probation, you have to approach it from the standpoint that somebody died and that I have like this much room for error. Because at the moment that it appears to this court that you are not taking this probation and this opportunity serious, I am going to revoke your probation. Miss Henry, I often say in this courtroom that probation is the alternative to jail and jail is the alternative to probation. You are going to have to lean into this probation with everything you have. It has to be your priority, because I'm not going to accept excuses for why you can't do this probation. There's only going to be one excuse I'm going to accept with respect to the fines, costs, and fees, not the restitution, but the fines, costs, and fees, because the law requires that if you're unable to pay the fines, costs, and fees, then I have to do an ability to pay, and I will convert that to community service. That's the only thing you're going to have space to tell me that you can't do. Other than that, I'm not going to be interested. So I'm letting you know up front that this is grace and mercy still in the room. Grace and mercy. Okay. I am going to accept the recommendation from probation for a 24-month, 2-year probationary period. Ms. Henry, I do believe that this case is actually the maximum penalty is a 5-year probation, but I'm going to sentence you to a 2-year probation. I'm also, Ms. Henry, however, going to sentence you to 6 months in the Wayne County Jail. I'm going to hold the 6 months in abeyance. Calm down, Ms. Henry. Come back forward. Ms. Henry, come back forward. Ms. Henry, come back forward. Now, I need you to listen to what I'm saying. I'm going to sentence you to the 6 months in the Wayne County Jail. I'm going to hold the 6 months in abeyance. That means, Ms. Henry, that the 6 months is going to be at the end of the probation. And if you have been a great and model probationer, if you are as remorseful as you have told this family that you are, then you won't have to do the 6 months. I'll hold it in abeyance. And if you do what I'm asking you to do or ordering you to do, you won't have to do the 6 months. But then also let me be clear about this. If I have to revoke your probation, right? If I have to revoke the probation, meaning you just utterly failing and you're not doing what I'm saying doing, and you're going to do it the year. If I have to revoke the probation, you're going to do the year. Okay? So you're not going to jail now. And as long as you do what you're supposed to do, you probably won't go to jail at the end. But you have a potential to do 6 months or a year. Do you understand? I want you to unmute and tell me that you understand what I'm saying. You didn't, what you doing?
She needs help to unmute.
Oh, okay.
Yes, I understand.
Okay, thank you, Ms. Henry. All right, so the court is going to impose 24 months probationary period. That would put a final review date of December the 18th of 2025. That's the final review date. You're going to come see me long before that, but that's the final review date, 2025, December 18th. I'm going to give you a 6-month review date of June the 18th. That's going to be your first review with me, June 18th, 2024. That review is going to be at 1:30 p.m. Okay. And then the court is going to impose the following conditions of your probation. And Ms. Henry, you don't have to try to write down what I'm saying.
Oh.
We're going to send you a copy of this order because it's going to be too much for you to write down. And I want you to kind of pay attention and listen. So the court is going to impose the mandatory cost of $210. I did note her source of income. So I'm going to, at this time, waive the attorney's fee. I am going to impose a $500 fine. I'm going to, restitution is to be determined. And we're going to set the restitution hearing for June 18th at 1:30. So that's, Mr. Flanagan, please make sure you put it on the docket for the restitution hearing is the most important, but also for the review.
Yes, ma'am.
The prosecutor will review the receipts that they have received, and the court will set restitution at that time. I am going to impose a reduced oversight fee. So the oversight fee I will reduce to $10 a month for a total of $240. A $100 pre-sentence investigation fee and $240 for drug tests. And I know already, Ms. Stevenson, that you're going to say, Your Honor, there was no alcohol involved in this, but she's going to test for me. I do
Ms.
know.
Henry expects that, Your Honor. We talked about that, so we're fine with that.
All right. So the total fines, costs, and fees without the restitution is $1,050. Nope, sorry. Oh, wait, I messed up. Okay, hold on. $1,530. And then with the following terms and conditions, ma'am, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor as to why they need to prescribe such an addicting narcotic. You shall not consume any alcoholic beverages. You shall not drive without a valid driver's license. You shall submit to random urinalysis twice per month. And I believe that may be at the 36th District Court. Now, I've added the $240. That's actually only half of the urinalysis. So I'm only at the 36th District Court, I'm only charging her $5 per test. But if she tests somewhere else, she has to pay them directly, and then we'll adjust the urinalysis. You shall submit to a mental health evaluation. I'm going to impose these two conditions that I know, again, alcohol was not involved as far as I am aware, but I still want you to watch the victim's impact, to attend the victim's impact panel and view the consequences video, because notwithstanding the fact that it wasn't alcohol, we need to understand that our distracted driving, or rush driving, and all of those things can have the same impact as a drunk driver. Trying to eat your hamburger and looking over here has the same impact as a drunk driver. Trying to text while you're driving has the same impact as a drunk driver. So again, I don't know specifically what you were doing in the car or whether you were just in a hurry, but you're going to do both the victim's impact panel and the consequences video. You are going to do the driver's improvement program. If you have any tickets, which the report doesn't, the report says you don't have any, but know that you cannot have a balance with 36th District Court. You cannot have any outstanding warrants during the course of this probation. And I'm sorry, I think I got ahead of myself. You shall not violate any criminal law of any governmental unit. That means you can't get a new case. You must not leave the state of Michigan without permission from the court. That means you can't go on vacation. If it's out of the state of Michigan, you cannot go without consent of the court. Okay. You must notify probation immediately of any change of your address, phone number, or employment status. And you must report to probation on a monthly basis. Ms. Henry, do not failed to report to probation. You don't only have to come see me on June 18th, but beginning January, you need to report in and check in with probation every month. Otherwise, that's a violation of your probation. I'm not going to accept that you didn't know. And if you can't reach a probation officer, then you need to call your lawyer, or you need to call your court, or call the courtroom. Okay. I'm also going to order that you attend the Choices program and the Marijuana Insight program. You have 2 years to do these things. Don't let it get overwhelming to you. Don't let it bombard, you have 2 years to do these things. And I want you to lean in. Oh, I think I missed one. I was going to order, did I say, where is it? I thought I checked it, but I may not have said it. I want you to submit to a mental health evaluation. So if I didn't say that, then I want her to submit to a mental health evaluation. We are going to mail a copy of the court's order to the address listed on the pre-sentence report, because there was no update to that address. And then probation is also going to contact you at the phone number ended in 1164. Anything further with respect to this matter?
Not from the people, Judge. Thank you.
On behalf of Ms. Henry, Your Honor, we are very grateful for the careful consideration that the court has given this case. She's very thankful for the opportunity, Your Honor, to do what she knows how to do, to stay out of jail. And I give the court the assurances that I'm able to give that Ms. Henry will, as the court has ordered, lean into this probation. And again, to the family, we are very sorry for your loss. You have our condolences.
All right. Okay, then we are all set. If the family members want to see the final order, of course, on the restitution, then you are free to appear for the June 18th restitution hearing. The prosecutor just has to confirm the receipts and share them with the defense attorney, and then we will address restitution on June 18th. All right, we're all set. Everyone have a great day as much as you can. Stay safe, and as much as you can, have happy holidays. I know that this time of year is difficult for people who have lost. I've had loss. And I understand. I can't say that I understand exactly how you feel, but I've lost a sister. And so I kind of, know a little bit about how you feel, and especially during the holiday season, but have a safe and peaceful holiday. And if you join us on June 18th, then we'll see you on June 18th. Everyone have a great day and stay safe.
Judge, could I have breakout with Ms. Henry before she signs off, please?
Yes. Okay, Ms. Henry, I'm going to send you back to the breakout room. And in fact, I'll close them since nobody's in there. Recreate. All right, Ms. Henry, I'm going to send you to breakout room number 2. Please accept to join that breakout room.
Thank you, Your Honor.
All right, you're welcome. You're welcome.
Yep. All right.
Okay.
Good.
All right. Whoops, the boxes are moving fast. I can't click everybody off. Okay. All right. Okay. Mr. Murat, Miss Ritter and Mr. Murat, I don't know why the jail would bring a person on here that's a tether violation and I don't have a tether report. So what am I supposed to do with that? Did I put Mr. Landis on the tether?
So, Judge, it's my understanding, I talked to Mr. Flanagan about this. He did advise me that none has been provided to this court.
Right.
I'm looking at
I think they said that none was prepared.
right, and so obviously, the court knows our position.
Well, I mean, I think Ms. Ritter know my position. I mean, I don't know what to say to a tether violation but Mr. Murat, I mean, okay. Mr. Flanagan, do we at least know who put him on a tether?
I'm searching his name now, Your Honor. I don't have his case number. We can find out.
Judge, if I may.
You may.
So, Judge, I don't know if the court remembers, Mr. Lynise was on tether from a felony case that was stemming from one case that he had with this court. And so he had a sentencing, and then there was another case where he was on tether for, but the felony case got dropped.
So then what does a tether have to do with me?
Because I believe the court did not remove the tether. There was already a bond emergency, or not emergency, but a bond hearing held, and the court did not remove the tether based on the arguments from the people and the complaining witness. This is the case, Judge, where, remember, Mr. Miller didn't show up?
Mm-hmm.
Oh, well, Mr. Miller didn't show up, so he didn't have counsel, but then Mr. Miller came again.
Oh. And doesn't Mr. Lynise need an interpreter?
Yeah.
No. I mean, he didn't. I asked him, he was talking to me.
Oh, he had an interpreter the last time.
He has had an interpreter every time.
You're right. I'm looking at the ROA. Everything was sort of
Yes. Okay. So, I mean, yeah. Okay. So at the very least, I'm going to adjourn it to tomorrow, and I need to get the interpreter. So he's not being held on a felony?
Not anymore. It looks like it was dismissed.
And what is his charge?
Oh, wait, I'm sorry. Hold on. Because I'm looking. He also has a fleeing third degree. Let me just see what his bond is on that.
Okay, because I don't think he should be in front of me.
Great. I guess he did a bond redetermination this morning.
In front of Judge McConaughey?
Yes.
And he put a tether on him, didn't he?
I don't know, because I got to find this fleeing case first.
Okay. Deputy?
Good morning, Your Honor.
Good morning, Deputy. Well, we're kind of at a loss and at a disadvantage if we don't have a tethered violation report. But I also want to know, Mr. Lynise had a bond redetermination this morning with Judge McConaughey. Did Judge McConaughey place a tether as his bond condition?
No, he just said I think the 30,000 continued.
30,000 cash surety or 10%?
Can't remember what he said, but
okay. But you don't remember a tether?
No, ma'am.
Okay, well, if he's on a $30,000 bond, I'm going to adjourn him to tomorrow. I need a tether report.
There is a tether, Judge, on the mechanical case.
Oh, well, then this is a moot point right here. I can't, if he has a bond, I mean, if he has a tether on a felony case, there's no need for me to do a tether violation hearing on a misdemeanor case. And I'm sure I didn't put him, I do remember not removing his tether because of some other stuff. Mr. Flanagan, when is his next court date on his misdemeanor?
February 7th for sentencing.
Okay. And Deputy, when is his next court date on his felony? Do you know?
I'm gonna look at the computer. Give me a second.
Okay, thank you.
12/27/23, Judge.
27th of December.
Oh, the 27th of December.
Yes,
okay, so then I'm going to do this. I'll continue his bond on mine. The misdemeanor courtroom is closed December 27th. That's only the felony courtrooms that are open. So I could put them on the docket for January 2nd and see what they did on the felony. And then we can, if we need to address his bond. But if he has a tether on the felony, that the misdemeanor case is mute. It doesn't matter.
Judge, can we put it on the 4th because his exam's on the January 3rd? So that way we'd have the result of that.
Okay, yes. January, his exam is January 3rd.
That's what the ROA says, yes.
Okay, well then, yes, we can put him on January 4th for me. And then Deputy, or Mr. Flanagan, somebody so let me say this. I think, I don't know this for sure, but based upon what I'm hearing, I think the tether violation is because he got in custody on the other case. That's probably what the tether violation is, that he was in the Wayne County Jail. So I feel like I'm going to dismiss the tether violation for me because I don't have a report. And I'm almost certain that that's the violation, the fact that he got picked up on another case. So I'll dismiss the violation on my case and set him a bond hearing for January 4th after we see what happens with the felony. Doesn't that seem fair?
That makes sense, Judge, because the
No, it
offense date
doesn't,
is.
Ms. Ritter. Why?
I used to stay home and do the.
No, not you, Ms. Ritter.
Well, Judge, I'm not going to say it's not fair. The people just want to confirm what the actual tether violation is, only because of the situation and the circumstances of what's going on with that case.
But you can confirm that by January the 4th. He's on a tether for Judge McConaughey's case.
Okay.
I mean, he's on a tether for the felony, 30,000 plus a GPS tether. He's on a tether for the felony. So, okay, so then I won't dismiss the violation. I'll adjourn the violation to January 4th.
Thank you, Judge.
All right. January 4th, after his felony case. Yes, sir.
If they the 27, I had the court for what happened, and if they give me a tether, I still got away here for January 4th, I go home. I'd be released.
Judge, may I?
You may, but you may.
Right. Sir, no, you have a personal bond on this case. This case wouldn't hold you up. If you get out on a tether, you get out on a tether regardless.
No. Well, he has a personal bond plus the tether.
Right.
So yeah, if he get out on a tether, he gets out on the tether. Yeah.
Exactly.
Yeah, okay. It won't hold him up.
And then I can go to court in person, right?
Right, yes.
Yeah.
Okay.
Yeah.
All right.
Okay. Apologize.
No problem. But Mr. Murad will be in touch with you.
Okay, George. Thank you very much. God bless.
Okay, thank you.
No.
Now he sure did know English right there. Okay. Mr. Murad, this is what I would like for you to do, please.
Yes, Your
Honor. As I indicated, of course, we're closed on the 27th officially, but can you just put a thing in your phone to check to see what happened? I don't know who his felony judge is, but if they let him out, so we'll know that he's out.
Judge Giles, that's the PCC.
Oh, Giles. Okay. Well, but somebody else is going to be. Judge Giles won't be here.
Oh.
So it'll be a stand-in judge, and I don't know who.
Mr. Ritter, I'm about to finesse him right out that tether as a 27.
No, you're not. You feeling like it could be somebody else. Okay, I won't even say it. It could be me. Could be me on the 27th. It's not. I'm doing the 20th and the 21st. Okay, let's I'm gonna take just a short break. When I say short, I mean it's 10:44. It's probably gonna be a 2-minute break. And then we can go straight through. If Mr. Flanagan, I thought it was can you tell me who the other person is that's in person? I have Hicks. Who's the other person?
Miss Rebecca Meyer.
Meyer. Oh, okay. Well, then we'll be ready on Meyer. So when I get back, we'll do Meyer and then we'll go through. All right, I'll be right back. I'm ready. Ms. Stevenson? Oh, Mr. Mariah, you're doing Myers?
Is he? Potentially, one moment, I just wanna. Yes, ready, Judge.
All right, this is case number. These are case numbers 234406801, 224451501. The people of the state of Michigan versus Rebecca Ann Myers. Meyer, the defendant is charged with, in each case, with one count of child abuse 4th degree, and today is the day set for jury trial as to each case. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Rebecca Meyer. Ms. Meyer, good morning again, ma'am. Please tell the judge your name.
Good morning, Rebecca Ann Meyer.
All right, today is the date set for jury trial. Are the people ready to proceed?
Judge, today is the day set for jury trial and the people are not ready to proceed. However, the people would like to make a motion. I'm sorry, your record.
Yes, you may.
Thank you, Judge. So, Your Honor, these cases both involve the same complaining witness, Ms. Zaylin Yellowbank. The people, in preparation of trial, did reach out to the officer in charge with respect to case number ending in 680, Detective Angelowski. He did assist the people in trying to locate the complaining witness, Ms. Yellowbank. From my understanding, Ms. Yellowbank is not in the care or custody at this time with Ms. Myers. We did try to reach the family members that were listed with CPS to try to get a hold of Ms. Yellowbank. Unfortunately, Judge, we were unable. Those numbers were out of service. At this time, Judge, people cannot proceed because we cannot locate the complaining witness in this case. And I do want to give the court assurance that the complaining witness is, I believe, 14 at this time, Judge. Still a minor, however, not a young minor, but we just cannot locate the complaining witness. So we will not be able to proceed to the trial that was set for today, Judge.
Okay, Ms. Ritter, you said only the one case. Is it the same complaining witness?
It is the same complaining witness for each case, Judge.
All right.
There's different OICs, so I only spoke with the OIC on the case that I stated on the record.
Okay. Ms. Stevenson.
Thank you, Your Honor. We want to give the court full assurance that Ms. Meyer has continuously abided by this court's no contact order. She continues to have no contact with the complaining witness, Your Honor. And at this time, we would move for dismissal for the complainant's failure to appear.
Okay. Today is the day set for jury trial. The people have been unable to locate the minor witness. I'm going to also make a record. Of course, I have no choice but to grant the defense counsel's motion, but I'm going to say this. I don't know the actual legal status of the 14-year-old, meaning the person who legally has responsibility for the 14-year-old. If it is Ms. Meyer, so for example, if there's no CPS case that says Ms. Meyer is not cannot have contact. If there's no court order that says Ms. Meyer is not the custodial parent, if there's not a guardianship in somebody else's name, and Ms. Meyer is the person who's supposed to have care, custody, and control of this minor, and she has not filed any complaint with the police department that the child has run away. She has not filed any situation saying she has no idea where her minor child is. And then miraculously, after the case is dismissed, the minor child appears to her. She's going to be charged with a lot of other stuff. Okay, so let's be clear that it is the responsibility of the
Judge, I'm sorry. May I go into the courtroom because it looks like Ms. Meyer wanted to say something, and I feel like I should stand next to her at this point, Your Honor. Excuse me.
Yes.
Thank you, Your Honor.
Okay. So if it turns out that Ms. Meyer is the person who has the legal responsibility for the complaining witness, she's going to be charged at my direction with interfering with prosecution, with tampering with the witness, and anything else that applies. So I don't know how much the prosecutor has looked into who has care, custody, and control legally of the person. But if Miss Meyer does, and she hasn't reported her child missing, then that's a big, huge red flag, right? That means she's confident and comfortable with who has her child, and she may know who has her child, and it's her responsibility to make them available to the prosecutor.
May I, Your Honor?
Okay.
Ms. Meyer absolutely hears and understands the court's position, and there is a legal guardianship in place wherein the person who does have legal care, custody, and control of the complaining witness is someone other than Ms. Meyer, and I believe it's as a result of these charges, Your Honor.
Okay. Well, what I'm gonna say to that person, I don't know if they're watching. I don't know. So if there is a legal guardian, they're going to be charged. I don't know who it is. We can easily pull up a legal guardianship. Wayne County records, Ms. Ritter. We can pull up the legal guardianship. So I'm letting the legal guardian know if they are watching, we are live streaming on YouTube. If they want to come back and watch it, I am going to direct the prosecutor to issue charges against that person. Or I'm going to, whatever I have to do, file a sworn complaint that they have withheld that child from these court proceedings. The child is 14 years old. They cannot refuse to come. They cannot decide not to come. And so that's where we are. Okay, so I'm going to go ahead and grant the defense request to dismiss the matter without prejudice. While the people locate the witness and the person who has care, custody, and control over the witness. Since Ms. Meyer is in person, Ms. Stevenson, we can submit the orders and I will sign them.
Okay. Thank you very much, Your Honor.
Welcome. Have a great day. Stay safe, ma'am.
Thank you, too.
I'm ready on Copeland. Mr. Murad, are you doing Copeland or Mr. Mr. Copeland, please start your video. All right, then I'm ready. Oh, I was just getting ready to go to somebody else. All right, this is case number 135671301, the people versus well, his name is Anthony. I mean, his name is Antoine. The record says Anthony Tyrone Copeland. And the defendant is charged with operating while intoxicated, driving while license suspended, revoked, denied. Today is the date set for pretrial conference. Ms. Ritter, though, Mr. Flanagan messaged me, and it appears that the mistake is the people's. He indicated that the booking information, and let me pull up the chat. He indicated that the detainee sheet has him as Antoine, but the complaint has him as Anthony. So I think that's an error on behalf of the people. So if we could, well, depending on what happens, but if we could get a corrected complaint, it appears that that's a mistake on behalf of the people. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Ryan Marab, ky6uqVyHiRc, on behalf of Mr. Antoine, who is listed on the docket as Mr. Anthony Copeland. Sir, please unmute your device and state your full name for the record.
Antoine Tyrone Copeland.
Thank you, sir. Today is the date set for pretrial conference. Mr. Murat.
Judge, with regard to today's pretrial conference, we'd ask the court to set the matter for a final pretrial conference. We'd ask for all discovery in this particular matter. Seeing that it is an older matter, I just asked for, that's it for now, Judge. That's it.
The court will continue a not guilty plea on behalf of Mr. Copeland. Set the matter for final pretrial conference. Court is going to set a final pretrial conference for March the 18th. 2024 at 9:00 a.m. Discovery should be submitted to the defense by February the 19th. Bond will continue, and then I do want at the final pretrial conference the people to confirm the availability of their necessary witness. So of course they don't have to appear, but the people, this is a 2013 case, it's 10 years old. So the people should confirm their necessary witness. And
excuse me, Your Honor.
No, absolutely not.
I come to court on the 18th.
What?
Sir, please keep your device on mute. I'll answer any of your questions privately in a breakout room. Please don't interrupt the judge. Sorry.
Okay, so, okay, all right, so Ms. Ritter, you got that?
Yes, Judge, I did.
All right. So is there anything for the record? Anything further for the record?
Not from the people, Judge. Thank you.
Not for the record, but Your Honor, if I could just be placed briefly in a breakout room.
Sure. Then we're all set until March 18th at 9:00, and I will send Mr. Copeland back to the breakout room.
You want to go or you want me to go?
You can go. I can handle everything else, I think.
Okay.
All right. I'm ready on Don Cove. Don Cuff. This is case number 224571001, the People versus Patrick Stephen Donkoff. The defendant is charged with malicious destruction of property. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Ryan Murad, PA3665, on behalf of Mr. Patrick Donkoff, who's present on Zoom. Mr. Donkoff, unmute your device, sir, and state your full name for the record, please.
Patrick Stephen Donkoff.
Did you say Donkoff, like the V is silent?
No, Donkoff.
Oh, okay. Thank you. Oh, Donkoff. That's how I was saying it at first, but then it didn't have an E, so I changed it. I should have kept it the way I said it. Okay. Today is the day set for pretrial. Mr. Murad.
Your Honor, today is the time of day set for pretrial conference. It doesn't appear that there's a complaining witness present. Accordingly, we move for dismissal.
Ms. Ritter.
Judge, I don't see the complaining witness, Mr. Gary Gardella, in the waiting room. However, it's the first scheduling of the pretrial conference in this court. I respectfully ask the court to adjourn the pretrial conference and give the complaining witness one more opportunity to appear.
The court is going to deny defense counsel's motion for dismissal, grant the people's request for an adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. Mr. Flanagan, how many do I have on January 29th?
$23.
Court is going to set the matter for January 29th. At 8:36, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness did not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further with respect to Mr. Donkoff?
No, thank you, Judge.
Mr.
Nothing further,
Murad?
Judge. I'm sorry.
All right, then we're all set, sir, until January the 29th. Have a great day. Stay safe. Happy holiday.
8:36, you said?
Yes, sir.
Okay.
All right.
Thank you.
You're welcome. Ms. Stevenson, did I send something on Griffin?
I don't think Griffin.
Let me see. Mr. Flanagan, can you send me the register on Delkeisha Griffin?
Yes, Your Honor, just sent.
Okay. Thank you. All right, this is ready on Robinson, case number 234550201, the people of the state of Michigan versus Ryan Cortez Robinson. The defendant is charged with assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Ryan Murad, PA3665, on behalf of Mr. Ryan Robinson, who's present on Zoom. Mr. Robinson, please state your full name for the record, sir.
Ryan Cortez Robinson.
Thank you. Today is the day set for pretrial conference, Mr. Murad.
Your Honor, we move for dismissal today for the complainant's failure to appear.
Ms. Ritter.
Judge, I don't see the complaining witness, Ms. Lena Robinson, in the waiting room. However, it's the first scheduling of the pretrial conference. I ask the court respectfully to adjourn the pretrial conference to give the complaining witness one more opportunity to appear.
Today is the day set for pretrial conference. The court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I am going to set the pretrial conference for January 29th, 2024 at 9 o'clock. Strike that at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Judge.
Nothing further, Your Honor.
All right, then we're all set. Until January 29th, sir. Have a great day. Stay safe. Happy holidays. Explain. All right, I'm ready on whoops. Ratcliffe. This is case number 204592401, the People versus Andre Dwayne Ratcliffe. Defendant is charged with 1 count of assault aggravated. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Andre Ratcliffe. Mr. Ratcliffe, sir, please unmute and say your full name.
Andre Ratcliffe.
Full name.
Andre Dwayne Ratcliffe.
Today is the date set for arraignment on a bench warrant. Ms. Stevenson.
Stand mute, waives reading of the information as to the plea of not guilty be entered on his behalf. We would ask that this matter be rescheduled for pretrial conference, Your Honor.
The court is going to enter a not guilty plea as to the arraignment on the bench warrant. And with respect to the scheduling, Mr. Ratcliffe has KPS about 3 times from a final pretrial conference. I will set the matter for another final pretrial conference. February the 5th. Mr. Flanagan, how many do I have?
$23.
Court is going to set the matter for February the 5th. At 9:04. The reason the court is setting it at 9:04 is because I don't know how many times we're going to schedule Mr. Ratcliffe for a final pretrial conference and then he not show up and then not have to post a high bond. Should you fail to appear on February the 5th, your bond is going to be revoked. The court is going to issue a warrant for your arrest. Your bond is going to be $10,000 cash surety plus a GPS tether with house arrest. If you fail to appear, the court is going to revoke your bond, issue a warrant, and set your bond at $10,000 cash surety plus a GPS tether with house arrest. Ms. Ritter, when is the last time that the complaining witness appeared, if at all?
Well, Judge, to be honest with the court, the notes that I have is that the complaining witness appeared back on the pretrial date, which was August 6th of 2021.
Okay, well, see if they want to still participate in the prosecution. I don't know that I'm going to dismiss it if they fail to appear because Mr. Ratcliffe continues to fail to appear. And so we're not going to keep doing that. This is the end of it. This is the end of his failure to appear.
Understood, Judge. The people sent out notification to the complaining witness to appear if they want to continue the prosecution.
All right. What bond did he post to get this court date? $10? Because I should revoke that. I should change that right now, but I won't. I agreed to participate in this low bond, initial low bond situation, but you taking advantage. Taking advantage, Mr. Ratcliffe. You're taking advantage. So, oh, I sure didn't want to look out the window and see snow just now. Okay. Anything further? Anything further, Ms. Stevenson?
Nothing further on behalf of Mr. Ratcliffe, Your Honor. Thank you so
All right.
much.
You're welcome. Then we're all set, Mr. Ratcliffe. Have a great day. Stay safe. Happy holidays. And we will see you February 5th, or we coming to get you.
Ms. Bryant, I understand, and I apologize for not showing up for the previous ones.
Okay. All right. This is your last chance. Let's do better, okay?
Yes, ma'am. You have a blessed day.
Have a great day. Stay safe. Okay, let me look at a couple of, let's go ahead and, no, I gotta look at the report. But I'm ready on Hicks. Let me pull up the report. All right, this is case number 224502301, the People versus Roderick Hicks. The defendant is charged with operating while visibly impaired. Today is the date set for review. Ms. Stevenson.
Janice Stevenson, appearing on behalf of Mr. Roderick Hicks. Mr. Hicks, sir, please tell the judge your full name.
Good morning, Mr. Roderick Hicks.
Today is the date set for review. According to probation, Mr. Hicks is on a 14-month probation and his term ends July 17th. Apparently, I amended his order on October the 10th. Reinstated outpatient treatment. He has completed several conditions, and then he must still attend victims impact. It says community service hours, but I don't know how many community service. 92, because I converted his money to 92 hours of community service, and then he'll have a balance of 135. He also has 2 outstanding tickets that he has to pay or get on a payment plan for. Ms. Stevenson.
Thank you, Your Honor. Mr. Hicks has a receipt in his hand for the $135, which was paid today.
Okay.
We'll continue to work with Ms. Lurs. Hopefully, he can see her after he leaves your courtroom to find out exactly how much community service he has to finish. He was not aware of the Victims Impact Panel until, he didn't recall any information about the Victims Impact Panel until we talked this morning. But now he knows he's also got to follow up with Ms. Lurs on that, who did note additionally in her report, Your Honor, that she has been able to work successfully with Mr. Hicks toward compliance with this court's order. So I would ask that the matter continue as scheduled.
Okay, Mr. Mr. Flanagan, does he actually have a court date? Let's see. What did I say? It's July 17th, and then let me see if that's still a good day for the court. Yes, it's still a good day for the court. Does he have a court date on July 17th?
Your Honor, it says July 18th, but it's in the system.
Yeah, that's good and probably better. All right. So we'll put him on for July the 18th. Let's put it at 10 o'clock. All right, so then he needs to go check on the community service hours. And then, like I said, get on a payment plan if he needs to for the other cases. All right, great job so far, Mr. Hicks. We'll see you July the 18th at 10 o'clock, okay?
Okay.
All right, you're all set. Have a great day. Stay safe. Happy holidays to you.
Thank you.
All right, you're welcome. And then we'll do Griffin, and then we'll go off screen for the last case, off live for the last case. Let me get the ROA. Oh, this is old. Oh, it sure is. Oh, let me print this. Hold on 1 second. All right. This is case number 05-576-5501, the People versus Delkeisha Monique Griffin. The defendant is charged. Well, my thing isn't printed. The defendant is charged with 1 count of malicious destruction of property. Today is the date set for review. Appearances, please.
P83665 on behalf of Ms. Delkeisha Griffin, who's present on Zoom this morning. Ms. Griffin, please unmute your device and state your full name for the record.
Delkeisha Griffin.
Today is the day set for a review by the magistrates. Ms. Griffin must have been in warrant status for quite some time. I have a copy of the original order signed by the late Judge Paula Humphreys. She was supposed to do 3 anger management classes, pay $135 restitution, $200 court costs, and no contact with complaining witness. And that was that's interesting. The order doesn't have a date on it. Oh, it was a non-reporting probation. Oh, July 27, 2005. And then on April the 27, 2006, probation said she failed to comply with any conditions, and they recommended 35 days on the alternative workforce. Mr. Murad?
So, Your Honor, that does make sense. I was trying to look for this case and I couldn't find it, which led me to the conclusion that it's not public, which led me to the fact that she took advantage of a HIDA plea. This case did go into warrant status.
This wasn't HIDA. You saying HIDA, but was this HIDA? Mr. Flanagan, is it non-public?
No, it's not. It's public.
It's public, Mr. Murad. It just might not.
I really couldn't find it on the ROAs or my courts or anything. But nonetheless, Judge, the court's absolutely correct. I talked to Ms. Griffin at length, and she candidly admitted that this was a long time ago. She remembers attending an anger management class, but not much else. I told him this court's not inclined to be satisfied with that type of behavior or conduct, really. But she found out about the warrant, Judge, and the action she took since is she turned herself into the Detroit Detention Center. She waited a day. She went to the arraignment courtroom and she was given this court date. She's willing to do what it takes to lean into whatever this court's willing to order. A little bit about her now, Judge, is that she wants this court to know that she has 7 children now, 6 grandchildren, an elderly mother she takes care of, no criminal history since this offense, which is something I can appreciate. I know the court does too. The only thing she remembers doing here is maybe attending an anger management class. So I'd ask the court to consider giving her a chance here to maybe comply with the original order. I know this court's not inclined to close these matters without improvement, even though I'd love for the court to engage in that course of action. But ultimately, my request, Your Honor, is for Ms. Griffin to have a short period of time to see how much she could really get done and if she can complete this order in a fast period of time. When obviously, if she's not able to do so, the court has plenty of sanctions and other things in the court's hand to fashion whatever remedy it feels appropriate.
Well, let me ask you this, Mr. Murad.
Yes, Judge.
Did your client offer any explanation as to why she thumbed her nose up at Judge Humphrey's order?
Judge, she was very honest with me. You know, when I talked to Ms. Griffin about it, she really vaguely remembers, you know, the procedural history of the matter. All she remembered was maybe doing an anger management class, and I pried on her, Your Honor, and I asked her, well, what, you know, I got to tell the judge something, right? What could it have been that just was something going on? And she didn't want to lie to me. She didn't want to create a story. She didn't want to just tell me anything. She was honestly and candidly did not remember, nor does she have an appropriate reason for me to tender to this court.
Okay. All right. You know, these type of cases really bother me. They do, where people just come to court, they get sentenced, and then they disappear. And they just, you know, they don't do what they're ordered to do. And you know, that's like sort of the ultimate disrespect to the court. This is from 2005. The order for the request for sanction is from 2006. I didn't become a judge until 2007. This is before I was even a judge. That's how long ago this was. She didn't find out about the warrant. She just ignored the fact that she didn't show up for court and didn't do what she was supposed to do. So there obviously was a warrant, right? So then she was reminded of the warrant, I don't know, by somebody for some reason. However, I suppose that people do get the benefit of my compassion, though a lot of times, you know, they don't even realize that they're getting the benefit of my compassion. So Miss Griffin is going to get the benefit of my compassion, in that I suppose if you say she doesn't have any new criminal cases, I suppose I'll take your word for it at the moment, but this is what we're going to do. I will reinstate her probation with the following adjustments. Number one, she's going to, well, of course, she long ago lost the benefit of the plea under advisement. We don't even use that word anymore, plea under advisement. It's delayed sentence now, so plea under advisement. So, okay, so she's going to lose that. So this will remain on her record, and she won't be eligible for an expungement except until 5 years after she completes her probation. Additionally, instead of doing 3 anger management classes, she's going to do 12. She will still pay $135 restitution. The court costs will increase to $210. Court is going to set a penalty, a probation violation penalty. I guess you could put that under that probation sanction, I guess, section, Mr. Flanagan, but that's going to be $250. I'm going to make this a reporting probation. It's no longer non-reporting. I'm going to set it for 6 months. And therefore, I'm going to also add 6 months of oversight fees. That's $210. The total owed is $805 plus whatever the late fee penalty that was added automatically by the court system. So whatever her total balance is currently, we're going to add $10 plus, that's $220, that's $420, $470. So Mr. Flanagan, you're going to add $470 to her current balance.
Okay.
And then I don't know how this is going to work. Miss Ritter, can you come on screen?
Yes, Your Honor.
So I do realize this is an old case. It's an old case. What I would like for the prosecutor to do with respect to this particular case, and this, of course, we're on Miss Griffin. So the prosecutor's office may have, I don't know if you still have your files. So I just want, if you do, because we have $135 that we need to forward to a complaining witness, if you could just look and see if you have an address, a former address. If not, I'm going to order that the restitution go into the victim's impact fund. She's not going to not pay it, right? So if we cannot locate the complaining witness, then the $135 will be sent to the victim's impact fund. And so,
Okay.
Mr. Flanagan, make sure you put that in an amended order.
Yes, ma'am.
All right. Mr. Murad, we also need to make sure that we have an updated phone number and address for Miss Griffin. Miss Griffin, we don't want to have to, I've been on the bench now for 17 years. We don't want to have to come, looking for you. So let's get it done. And then if you get it done, I have to look up the, somebody need to look it up. I don't know if it's going to be me. Mr. Murad, maybe you need to look it up, or your office. So it's my position that the court has no authority to grant a delayed sentence after the initial sentencing if the probation hasn't been complete within the 12 months. That's how I read the statute. If that's not the case, if there's a case out there that says, like with Miss Griffin, she was violated and capious within that 12 months. So if I can reinstate it and then allow her to finish within, I guess technically it's still in 12 months. I don't know. I would consider still giving her the delayed sentence so it doesn't appear on her record. But I need case law because I'm not going to do it against, my authority.
Will do, Your Honor.
All right. Let's set a review date for 3 months so we can see where we are. That will be March let's see. I'll be gone. Let's just put it on for March 18th at 10 o'clock. All right. Anything further with respect to Ms. Griffin?
Judge, the people did find phone number and the address that we have on file for the complaining witness.
Forward that to Mr. Flanagan so he can forward it to probation so they can try to see if it's still valid. And if not, if they can't find her, then it'll still go to the Victims Impact Fund.
Okay, I'll email that to Mr. Flanagan now.
I mean, I said Victims Impact, but it's what's it called?
Crime Victims' Rights.
Crime Victims' Rights. Yeah, Crime Victims' Rights. It'll go there if we can't find a witness.
Okay, Judge.
All right. We're all set. Mr. Moran, I'm assuming you do have an updated address for Ms. Griffin?
I do, Your Honor. I'm forwarding that to Mr. Flanagan now.
All right, Ms. Griffin, you're all set until, what did I say? March 18th at 10 o'clock.
Thank you, Your Honor.
All right. Okay, and then I'm gonna go off the live stream for the last case.